Welcome back to State of Belief Radio. I'm Religion News Service Editor-in-Chief Kevin Ekstrom, filling in today for Welton Gaddy. The timeline is a little bit complicated, as human rights activists wait for the Obama administration to issue an executive order mandating protections for the LGBT employees of federal contractors. A piece of legislation extending those protections to all workers, called the Employment Non-Discrimination Act, has been passed by the Senate and now needs to be taken up by the House. Here's where things get tricky, because ENDA has been a priority for human rights organizations for 20 years. Yet in the aftermath of the Supreme Court's sweeping ruling in the Hobby Lobby case, a number of those organizations recognize the radical degree to which the language of religious exemption could now potentially be used to undermine anti-discrimination rules. And so, with the National Gay and Lesbian Task Force leading the way, a number of those organizations withdrew their support from ENDA in its current form. And here to discuss what may have been an extraordinarily difficult decision is the NGLTF's Stacey Long Simmons. Stacey, welcome to State of Belief Radio.
Thank you.
So how long has the National Gay and Lesbian Task Force been working for ENDA to pass?
Well, we've been working on this very important piece of legislation, this very important issue for over 20 years, and it was not a decision that we took lightly. We definitely came out in opposition to ENDA after we realized that there had been a huge sea change. The day after the court ruled on Hobby Lobby, we realized that this was an incredibly, markedly changed political landscape. We had already been witnessing changes at the state level in terms of discriminatory law being passed in Mississippi, as well as several ballot measures that we'd been involved in beating back that had broad religious exemptions. And we just became concerned when the court took it even further and folded into the religious exemptions, exempting from law, when they folded in private entities like Hobby Lobby.
So can you explain, for folks who may not understand all of the legal mumbo-jumbo, what the contraception case in Hobby Lobby has to do with gay rights? There's an exemption here that's at issue, but what does one have to do with the other?
Sure, but first, before I answer that, I just want to make sure that I'm clear. We understand that religious freedoms are constitutionally protected, and so we're not saying that we need to do away with all religious exemptions. What we're talking about here is a situation where the court is basically saying that a private entity like Hobby Lobby is able to go around what is currently federal law in the Obamacare, the Affordable Care Act. And under that law, employers are required to provide their employees with access to contraception. And so to invoke religious beliefs as a reason to not provide employees with accurate and medical care in the form of contraception is just really unacceptable in our minds, because we believe that that's really not the business of a boss to be able to make decisions about a woman's health care. So how that relates to LGBT rights is there really historically been twin movements, the LGBT movement and the women's rights movement, because it's really about being able to have autonomy over our bodies as consenting adults, and to be able to have privacy protections and be able to have certain rights protected in law. So in this instance, we've been focused primarily on employment discrimination and ending employment discrimination, and we're concerned that if the court is going to take turn a blind eye to what a religious employer would do, that could extend to all sorts of different contexts, and that people who are hardworking individuals who really are doing a fantastic job at work would be dismissed from their jobs or not promoted or be overlooked just because of who they are or who they love.
So in essence then, if I'm hearing you correctly, what you're saying is that the legal principle in the Hobby Lobby case that allows employers to cite religious beliefs in denying contraception coverage would be the same religious exemption that would allow them to discriminate based on sexual orientation, that they're two separate issues, but the legal principle here is the same. Is that right?
Yes, I'm basically saying it's a slippery slope, and that is really what sounded the alarms for us. And I have to say, I'm a person of faith myself. I'm a Christian woman, and I'm a person who was raised with a set of beliefs. And the primary belief that I uphold, and which many of people of faith, in fact, we heard from many people of faith who actually felt like the religious exemption in ENDA was too broad, is that it's important to distinguish between what happens in the workplace and treating people, following the golden rule, treating people as you want to be treated, and preserving for people a foundation where they have the right to worship and believe what they choose, but not crossing those lines, crossing those over.
So the task force isn't the only group that has pulled its support to the exemption language in the Employment Non-Discrimination Act, right? I mean, there are other groups that have joined you in this?
Certainly. There are a number of legal groups and a number of other advocacy groups that have pulled support, and also, on the heels of Hobby Lobby, sort of making the same assessment of the changing landscape that we've made.
So what would be required in order to get you back on to supporting ENDA?
Well, what we're calling for is we want Congress to extend the same protections as those are contained in Title VII of the '64 Civil Rights Act. And, that's very simple. We believe that legal equality is legal equality, and that there shouldn't be a free pass on the basis of religion for those who want to discriminate against LGBT people. And what that really means is that the current categories of race and sex and national origin and color and those historic protected categories, we're just saying that LGBT people, sexual orientation, and gender identity should be included among those who are protected as well in this context.
So would amending that law from the 1964 to include LGBT people, that would basically do the same thing that ENDA would do, but you would not be getting into the religious exemption language that's currently there, correct?
Well, right. So what's currently there in terms of the religious exemption language is it's really the Civil Rights Act is specifying that the churches and houses of worship, they get to have a preference towards people of their own religion for certain jobs. And what ENDA, the current language of ENDA did was said that those same entities actually got a free pass. They could discriminate and make choices not just based on religion, but also if they objected to sexual orientation or gender identity of their employees. And we're saying that's not okay. We're saying that, these aren't positions where you're putting someone in the pulpit or you're having someone preaching to the pews. We're talking about roles like a janitor or housekeeping staff or somebody who's a nurse or a doctor working at a religiously affiliated hospital or university. We just feel like that circle is just too broad. There's too much at stake.
And to be clear, not all gay rights groups have pulled their support for ENDA in its current form. I believe the Human Rights Campaign still supports it, and this has been a big priority for them. So has this sort of created a bit of a rupture within the gay rights movement?
Well, one thing is for certain, we're all singing from the same sheet of music with respect to concern about the overly broad religious exemption in ENDA. So while there may have been some groups that made a different choice in terms of opposing the current bill, I believe that the national groups are uniformly in agreement that the religious exemptions are overly broad in the current iteration of ENDA.
So last question for you. I was just talking with Rabbi David Saperstein at the Religious Action Center about this clash between individual rights to not be discriminated against versus religious rights. People to have the freedom to express their faith in whatever way that it's manifested. So, in your mind, where is the balance there between these two competing rights? The rights of religious employers, for example, but also the rights of LGBT people not to be fired for who they are.
Yeah, I think that this is a really complex issue that we could certainly do a weeks-long radio program on this, right? But just to cut to the quick, I think that what's important to acknowledge is that an employment, a place of employment is not a place for discrimination. And so if an individual employer has a particular belief about religion, I think that, we've got to draw the line because right now there are plenty of people who want to be able to access businesses and services, and there are shopkeepers, owners who they're using religion as a reason to turn customers away, which we don't believe is a very smart business practice. And there are lots of Fortune 500 companies that have non-discrimination policies in place. So it's a longer conversation, I guess, is my answer to that.
And I suspect we'll be talking about it for quite a few weeks to come. Stacey Long Simmons is the Director of Public Policy and Government Affairs with the National Gay and Lesbian Task Force. Earlier this month, her group led a number of human rights groups in withdrawing support for the Employment Non-Discrimination... Stacey Long Simmons is the Director of Public Policy and Government Affairs with the National Gay and Lesbian Task Force. Earlier this month, the task force led a number of human rights groups in withdrawing support for the Employment Non-Discrimination Act as it's currently written. Stacey, thank you very much for being with us today on State of Belief Radio.
Thank you so much for having me.